I had this situation happen where we were going through probate. My client was the sister of the deceased, and she was the only living heir, and she found an investment account and contacted the company to get it to bring into the probate estate. And they said, we're sorry, but we've already distributed it to the beneficiary. And I call them and I said, she has no living heir. She's not married. Who could this beneficiary be? And it was the ex-husband that was still listed on the beneficiary designation from when they were married, and they had been divorced for over 22 years. And he got this money. It was over $300,000.
Welcome to Redefine Retirement with Ryan Wheless, powered by Allied Wealth. This podcast explores how to live a limitless life of abundance in retirement with clarity, purpose, and confidence. Welcome to another episode of Redefine Retirement with Ryan Wheless. Today, I'm joined by Crista Hermance, estate planning attorney and founder of Hermance Law. She's also a mama too. Krista helps families protect their legacies with compassionate, practical estate planning. Recognized by Best Lawyers, Ones to Watch, and Law Firm 500, she brings expertise from her business and legal background to secure what matters most, your estate. Krista, welcome to the show. As you know, folks, we are all about going out into the world and finding information that you can use to make your life better when it comes to planning for retirement. And planning for retirement really should begin with the end in mind. Now, a lot of us overlook that. And what I mean by beginning with the end in mind is, I plan my life around my funeral. And my goal is to have my funeral standing room only, with people in the room talking about how I made their lives better in some way or capacity. That's my dream, right? But more than that is, what about what happens to my stuff when I'm gone? What happens to my car, my watch, my stuff? But what about my money? What about my real estate? What about my life insurance? And so that's an estate plan. And so any good financial plan is going to have components of an estate plan associated with it. And I think that's one of the most all overlooked parts of retirement planning. So I've gone out and found what I believe to be one of the best estate planning attorneys in the business, Miss Crista Hermance. So Krista, welcome to the show. It's a pleasure to have you.
Thank you so much for having me, Ryan. I appreciate it.
So tell me, what do you think is the most overlooked part of estate planning? And I know we can get into trust and wills and probate, advanced directives and healthcare power of attorney, durable power of attorney, medical power of attorney. I mean, there's so much stuff out there to navigate. I mean, what do you feel like some of the most common overlooked areas are that people should focus on?
I honestly think it's that people think they have more time and that they just don't need to do the planning yet.
That's awesome.
I see that so often for families when they come in to us in a kind of a crisis planning situation. And whether it's somebody that's older and they have illnesses, or even when it's a younger family and, a husband under the age of 40 has a heart attack, right? Is that they always just think they have more time. And it really just leads to a lot more emotional impact on the family, because now they're not only dealing with some substantial impact from somebody's health, but also dealing with how do they fix what didn't have a plan before. And it adds more stress, and it generally costs a lot more money to have to deal with.
Yeah, I see that a lot. I've got, in my industry, unfortunately, one of the things that I never realized going into it is when someone hires you to be their financial advisor, there's a strong chance you're going to see them to the end. And I've done it many times. And even as much as we help people prepare, there's oftentimes a sense of unpreparedness that happens. One of my clients, her husband just passed away, and she called me and says, Ryan, I had to get my Social Security check for my husband's Social Security check this week. And I'm like, well, you're not going to, because the funeral director notified Social Security of his death, and we have to call Social Security directly and make a claim. And we need to get on the phone and do that together. But we can't call Social Security right now because the government shuts down. So even in that sense, there's just a lot of things that go, you can plan well, and a lot of sticky things out there that can still come up and rear their ugly head. Is there like some guidance or an advice that you could give some folks, Krista, that can really help them, prepare and talk about some of the things that we need to know about and be ready for?
Well, I think it's really that anybody over the age of 18 needs to have some type of plan. And this is very eye-opening for a lot of families that have young adults where kids are just turning 18, maybe going off to college, they alone should have a power of attorney, an advanced healthcare directive, and a HIPAA authorization. Because what I find is that if they were in an accident and they were unconscious in the hospital, the family would have no ability to talk to the doctors and understand what was going on. And I have actually had this happen to clients where their kids went away to school and they were in an ambulance, unconscious, going to the hospital, and the hospital would tell them nothing. Right. So even from the age of 18, there are a limited number of documents to just make sure that there are legal plans in place. Right. I've had clients where the parents come to us because their adult children pass away under the age of 30, and now they can't get access to their Apple accounts, right? They can't get all of the pictures from their iCloud accounts. And so there's things and, certain types of platforms make it easy to identify if something were to happen to me. Here's people that I would want to be able to log in and be able to get access to my accounts, right? So there's just things that people put off and they don't do. But especially if there's property involved, right? If there's minor children, there's generally going to need to be a will and a trust that's created that gives that information about if something were to happen to you, what are the things that you would actually want to happen. And I'm a licensed attorney in the state of California. And so probate is different in every state across the country. And so it's, it really is dependent upon your state. So it's always important to work with an attorney in your state to understand if something were to happen to me, what would happen to my assets, what would happen to my family, because there's just a lot of misconceptions. Like I just had somebody in a workshop last week where her husband was literally in the hospital and they were not planning on him going into the hospital. And they had put off doing their estate plan. And she's here going through this emotional turmoil of her husband's in the hospital. She's not sure if he's going to make it out. She's trying to get the plan done. And he just told her, don't worry about it. Everything's going to go to you anyways. And so many people think that when it is not the case, right? It depends on the assets you have. It depends on how it's titled. It depends on what your family structure looks like. And, people just think, oh, it's automatically going to go to my spouse or to my kids. And that is not always the case.
Yeah, it's very true. We've seen some instances where people have even gone out to do trust work, for instance, and they don't take the time to coordinate their financial advisor and the accounts at Fidelity, TD Ameritrade at the time, Charles Schwab, wherever they are, right? They don't make sure the beneficiary designations at those accounts and custodians, 401k plans match the document or match the verbiage and language in the trust, which is a very detrimental thing because my understanding is, I'm sure yours is too, is that whatever is on that beneficiary designation at that custodian, that is the trump card. That's where the money flows to. Now you can have that point to an individual person or your trust, all right, but that's where it goes to. Is that accurate?
That is accurate. Yes. And I had this situation happen where we were going through probate. My client was the sister of the deceased and she was the only living heir, and she found an investment account and contacted the company to get it to bring into the probate estate. And they said, we're sorry, but we've already distributed it to the beneficiary. And I call him and I said, she has no living heir. She's not married. Who could this beneficiary be? And it was the ex-husband that was still listed on the beneficiary designation from when they were married, and they had been divorced for over 22 years. And he got this money. It was over $300,000.
That's insane. And that's just one of these little things, and you can even go as far as getting your estate planning done, but not point the beneficiaries on your accounts to your estate plan. And what you think is going to happen when you pass on isn't going to happen, even though you feel like you've taken the necessary steps to make that happen. And that's one of the big things that we do at Ally Wealth is we're very focused on coordinating with your estate planning attorney and your CPA to make sure that the moving parts that we're managing for you are also moving in a copacetic way with your estate planning, your tax situation. And I think a lot of advisors overlook that aspect. Let me ask you this question. So, we talk about probate, right? I mean, why is probate bad? Why? I mean, I've got $10 million, $20 million, whatever I've got. Why would and I've got 2 kids, by the way. What's wrong with my $10 or $20 million estate going through probate? I'm dead. I'm gone. Why does that matter?
Yeah. So there's quite a few things that I think are wrong with probate. And it's really a matter of what you want to happen with your stuff, right? If you're okay paying very substantial fees for having to go through probate, and I don't even know what the number is off the top of my head for, in California, it's based on the value of the estate. So the cost is pretty substantial. So a $2 million estate would cost $56,000 to go through probate. So that's why I said I don't know off the top of my head how much a $10 million estate would be, but it's $56,000. And a lot of times the families can't afford to pay the cost when somebody passes away, so they're having to sell real estate, right? They can't keep the property in the family. So one thing, it's very expensive. The second thing, it's public. And for most people, they want their private life to be kept private. But when they pass away and it has to go through probate, everything is put out there. Your personal information about what assets you owned, who your beneficiaries are, who your creditors are. And it could lead to predators, right, that are now know what's going on in the estate. They know who's receiving. They could try and befriend them. They could try and, say, I have this business deal. So there's just more opportunity for, fraudulent wrongdoing in these types of cases where they might be taking advantage. And then the last is it's a very long process. And so probate in the state of California generally can take anywhere from 1 to 3 years, right, depending on the county that it is. I had 2 hearings in my firm this morning in 2 different counties throughout California. One, the next hearing got sent 2 months out. The next one in a different county, it got sent 6 months out, right? Just for the next hearing. And so it depends on how many cases are going through probate, what the court system looks like. And so what that means is that if the assets, and I see this with retirement accounts, unfortunately, they're not working with an advisor. They're, that's something that they are doing through their work or they've done online themselves. They don't have that type of, that type of guidance, and they have no beneficiary listed on the retirement as a beneficiary. And so now that retirement account is having to come through probate. And so what that means is that from the time that person passes away until the very end, when we get the court order, that is when the beneficiary actually has access to the money. And so you could have a family that is waiting and needs this money to be able to survive and live, and they have no access to the money because it takes that long to go through the process.
And that can especially happen with younger families in the event that there's a tragic death or something like that and no life insurance. And I've witnessed that before, by the way. I had another case too that was interesting. The husband and wife were second marriage, and the husband had a business, and he had a account in his name only at I think it was Fidelity or Schwab, or I can't remember. This was back in 2008 when this happened. Well, he died, and the majority of the money they had was in this account, but it only had his name on it. And this guy was investing very aggressively in stocks. And so he died early in, I think it was early October of 2008. The market crash started happening mid-October. And this lady was watching the money she was going to use to financial lifestyle and retirement just plummet. And she could not touch that money until the end of 2009. It took that long. And she watched that account value just drop, and she couldn't do anything. She's like, Ryan, can we call these people and tell them to put me into cash? I'm like, we can. They're not going to. They can't take our directives on this account because no beneficiary is listed. There's no will pointing the account to you. There's no medical power of attorney, durable power of attorney, or financial power of attorney that you signed. And so we're powerless here. And I just, it's one of those things where I'm so glad to have you on the show, because I think this is such an important aspect. And you just blew my mind with somebody being 18, needing advanced directives. Are you kidding me? I never even thought about it. That's awesome.
Yeah.
So you do some work with younger families, right? You've got your Bumblebee Foundation. Let's talk about that for a minute. What do you do there?
Yeah, so I'm on the board for the Bumblebee Foundation. The Bumblebee Foundation supports families where there's children that are going through cancer, and so it's a local organization here, and actually has stemmed to Idaho at this point. But it's being able to provide the families the support when their child is diagnosed with cancer. Maybe they need gas cards to be able to get to the children's hospital. Maybe they need a car, right? Maybe they can't afford a car payment. And so, to me, all of the organizations that I'm involved in, it's generally supporting children. I just had somebody reach out to me yesterday asking for help trying to get together, like essentials for kids that are put into foster care, right? Like they need toothbrushes and toothpaste and underwear and socks and, just something that will kind of just help them feel a little bit more comfortable. And to me, it's always about giving back in the community to help kids, because I feel like kids are really where they're the most vulnerable, right? And I feel like they're the ones that can get taken advantage of the most. And especially when it comes to estate planning, I think that people have the right intent with wanting to protect their kids. But like with life insurance in California, children under the age of 18 can't inherit money or property. So if you list a minor child as a beneficiary on a life insurance policy, they're not actually getting that money. And people have the idea like, I need life insurance. I need it to make sure my family's protected, that my kids are going to be taken care of. But now, because you didn't have a trust in place and you didn't have that life insurance beneficiary as your trust, that money is going to the kids where it has to go through court, and it's going to go into a court blocked account until they turn 18 years old. So if they are young, they have no access to that money. Or maybe it's a divorced parent situation and you were to pass away and now your spouse gets full legal custody of your child, and now they're petitioning the court for guardianship to get access to those life insurance funds, right? Would you want your ex-spouse to have the life insurance funds that you had for your child? Or does it make sense that you should have had a trust where you can identify your sister to be able to be the one that's in control of the money for your child, right? It's not your ex-spouse. So there's a lot of intention there to take care of kids, but people just don't understand that there's more steps that they need to do from a legal perspective to make sure it's in place.
Yeah, it was a challenge for myself. My wife is 30, I'm 48. My wife is 36. And my daughter is 8 years old, and my son Jack is now 6 years old. And so we were doing our estate planning. And, even with me, I'm sitting there going, well, this is some interesting stuff that I'm kind of feeling about my clients. Cause I'm like, hey, you guys need to get your estate planning done. And sometimes I've seen them get in knocked down, drag out fights about things. Your kid didn't do this. Your kid did drugs. Your kid was a good kid. Your kid went, and I've seen all kind of stuff, but it was really interesting for me because I'm like, well, if I die, I want my wife to be happy, go remarry, go find somebody. Right. But wait a minute. What happens if that person's not an actual good person? And now the wealth that I worked my tail off to build that's intended for my kids to be there. Well, what happens if that person's unscrupulous for that wealth and spends my kids' money? But then the other aspect is, well, should my wife have the right to live off what we've created together in the interim and then still remarry and then, have my children still get what's rightfully theirs from my estate? And navigating this stuff can be daunting,
Yeah.
What are some ideas you have to help people with that, Krista? Because that was, even for me, it was a hard thing to go through.
Yeah. Well, I think it really comes down to, what do you want, right? Because when you focus on what you want, then it's creating the plan to be able to build that so that it's legally in writing that will allow those goals to be accomplished if something were to happen. And I think a lot of times people put off estate planning because they don't want to get into those circumstances where there's going to be some type of disagreement or argument about how things are distributed or who's going to be the guardian of the child. But something is better than nothing in place, right? Because again, you're kind of just leaving it up to how our beneficiary is listed or how his title held. And a lot of times people don't really think through the logistics of if something were to happen, right? Like people will say, well, I can give you like 5 reasons. People tell me all the time, oh, I'm just going to do this and not do an estate plan, right? Like they try and get around it. And one of them is, I'm just going to identify beneficiaries on all my accounts, right? And I said, that's, it's great to have beneficiaries, but what happens if you get sick? A beneficiary only comes into play when you pass. And so if you get sick and you're in the hospital and you're unconscious and now you're having to come home and you don't have capacity and you need in-home care, well, guess what? Nobody can access your checking account because you only listed a beneficiary designation. So they only get access when you die. And it's 40 days generally after you die that you actually get access to the money, right? But if you have a trust and it's listed in the name of your trust, now your trustee can step in and be able to help, right? In that instance, to be able to take care of you. So people don't really think through it. And then that's where we get into crisis planning. And now because nobody has access to the money, we have to go get a conservatorship with the court. And that's going to cost 3 times the amount of money it would have cost to just get an estate plan done in the first place.
You have to pay for that, right? An attorney's going to represent you, but they're going to want
You
a payment,
have
a
to pay
retainer
for
up
it.
front, $25,000 in a lot of cases, which is a lot of money. I mean, that's a lot. I'm not berating attorneys by saying that, by the way, but it's a lot up front to pay, and you've got to come up with that money, because if you don't, your mom or dad's sick and you're trying to access their accounts and you don't have the money to pay for it. It's a conundrum.
Yeah. It's honestly, when we are in situations like that, they have no access to money. So they're having to pay everything themselves, right, to get started until we can get them access to the money and then reimburse them. But it's unfortunate because there's a lot of families that can't afford to be able to pay all of the fees that are going to have to be paid through that.
When we talk about an estate plan, like do you have like five pieces of it, or six pieces, some elements that the folks that are watching can know, okay, Krista said these 6 things. I'm going to make darn sure I've got these 6 things. Can we kind of walk through something like that?
Yeah. So I will say for our basic plans, there's probably like 12 things, but I will say like there's kind of like the big 5, as I refer to them. The first is a power of attorney, right? A power of attorney is for financial purposes. It is not anything related to healthcare. It doesn't have to do with the will. It is specific that if somebody is incapacitated, they would be able to step in to be able to assist. What people don't understand is that the power of attorney is not the only document you need, right? Because all of these documents I'm going to mention, they work together as a comprehensive, complete estate plan. It's not one document, it's all of them. So power of attorney for financial decisions. Then you have a healthcare directive, which can be also known as a living will, right? This is where it gets confusing. The healthcare directive or
a living will.
Exactly. They're two different things. So a healthcare directive, or a healthcare power of attorney, as it's also been referred to, is where you identify an agent to make those healthcare decisions on your behalf if you are unable to do. Certain end of life decisions are put in there as well. So that's number 2. Number 3 would be a will. Right? A will is still important to have, but it is not the only thing. And that's what I hear a lot of people say is, oh, all I need is a will and my family's going to be taken care of. Well, that's not true. A will alone does not avoid probate court. So if your goal is to avoid probate court, a will alone is not going to do that. But a will is still important to have, because then it works with a trust. Right? A trust, also known as a revocable living trust or a living trust. This is where you have this agreement where you're going to put your assets in the name of your trust, right? You're not losing any control of your assets by doing this, but it is an agreement that has very specific instructions, and you as the trustee is listed as the person in charge. And so this gives that if you were sick, the ability for your executor or a successor to come in and be able to step in and handle things. Okay. And then the last one I'll mention is the guardianship. Guardianship nomination, it can be done separately. Sometimes it is put in a will, but if you have minor children, it's important to have guardianship nomination for those minor children, so that if something were to happen to you and the other parent of the child, it's clear who you would want. Because if you didn't have this documentation, you have a court making a decision where they have no idea who you would want, and it could be somebody you would never want to be in this role that the court would identify.
That's interesting to me. Very, very interesting to me. And that's a struggle that my wife and I have had, because we are blessed. We own our own airplane and we fly the airplane around. I'm a very seasoned pilot, been flying for a long time, got every flight rating you could have except for rotorcraft. But it's a concern because my wife and I are flying our plane from time to time without our children on board. And it was a struggle for us to pick who we picked for guardianship. And I'm really glad you said that when, pick somebody, because the court could pick somebody you don't want, right? What are some ideas you have around that? I mean, you've got some good experience. How can you help help families navigate? Is it Uncle Bob? Is it Aunt Sue? Is it, my buddy from college? Is it, my neighbor? How do we navigate that stuff, Krista?
So lots of things to take into consideration. I will say that a lot of times for families that have minor children, this is probably one of those points where if they can't agree, they just don't do it. Right. And
we see that a lot, but they do nothing. Yeah.
Mm-hmm. They do nothing. And so there may need to be some compromise, right? And so maybe, think of when you're nominating guardians, I generally recommend identifying 1 primary and 2 backups. So for a total of 3. So maybe it's not, this person's not first. Well, maybe they're second. things to take into consideration is, what are the ages of the guardians that you are nominating, right? For a lot of our younger families, they want their parents. And so I'll have the conversation with them and I'll say, okay, well, how old are your parents? And if your parents are 80 and you have a toddler, what is that going to look like from a lifestyle perspective for your parents and the toddlers, right? Growing up. And so it's, well, maybe it shouldn't be your parents, right? As the guardians, right? Specifically. And whoever you choose, it's important to have conversations with them so that they know, right? They know what your wishes are and the reasons that you've made these choices. A few other things to take into consideration is, where are the guardians located in comparison to where you live, right? Is it going to be really hard if you have teenage children and they're taken out of high school and something were to happen and they're moved all the way cross country from the West Coast to the East Coast? Is that going to be a major impact on their life at that stage in their life, right? And so that's one thing. How well do they know the family or who is going to be nominated as guardians? Between me and my husband, it is very important for us that my kids know who these guardians are well and that they're comfortable with them and they see them annually so that they are continuously having relationships with them, so that it's one less thing that's going to have an impact on them if something were to happen to us, right? So having that relationship with them. And then what does the family look like of the guardians that you would be identifying, right? Like the baby boom situation, like you have, somebody that works 90 hours a week and has no children. Well, is that going to be the best lifestyle for your child? Or is it somebody that maybe has other kids that they're going to be able to have siblings essentially in this family? And so there's a lot of things to take into consideration, logistically when looking at guardian nomination.
That's a lot.
It helps you though. And I tell people all the time is make notes, right? Just put everybody down in writing of who you think, and then start making a list in order. Let it sit for a day or two. How do you feel about it? Right? Does it feel like it's good? You're comfortable with it, or you feel anxiety towards it, right? Then okay, maybe we need to shift some stuff around. I had a client that came in on a Friday to do their estate planning. They designed the plan and they put close friends, because it doesn't need to be family members that you're identifying as guardians. It could be, close friends that you have that know your family. And they went camping with their friends that weekend. And they called me Monday morning and they said, we need to change our guardians. We saw how they were with their kids over the weekend. We're not okay with it. We do not want them to be guardians anymore. And so, they made that decision, but they changed it. And that's the great thing with estate planning is once you put your decisions in writing, as long as you have capacity, you can make changes throughout your life on any of the documents.
We made a change already with guardianship for sure. Yeah. That's interesting. It's a tough thing to navigate. I've got a client that I'm thinking about right now. If I talk about the story, they're gonna know I'm talking about them, which they're great people. I'm not disclosing personal information about them, but they to this day they've been clients of mine for 12 years, and I have been trying to get them to get their estate planning done. Blended family, both did very well, but there's gonna be. I got my guys. If you don't get this done, the family unit you guys have worked hard to build as blending two families together is going to be destroyed. It's going to happen. I mean, I have seen people in knockdown, drag out fights, not talk to each other anymore over something as simple as who gets grandma's dishes.
It is so hard to see families in that situation where they literally hire us to coordinate going to the parents' house to get photographs or crafting supplies or pots and pans, because they cannot have conversations with the family where they are not fighting and yelling at each other. And both sides now have to hire attorneys to coordinate who is going to get, I kid you not, scrapbook supplies. That's what sticks out to me in this one family. And it's just so sad, right, that it gets to this point. But if it is not legally in writing with what your wishes are, and be very specific, because if there's room for interpretation, that's room that it's going to go to court for a judge to interpret it. Or now we have to go to mediation to figure out what that interpretation is. Be very specific. Say the reason that things are done, because then it's going to help that if there's a question about it later, hopefully it's answered within that question.
Yeah, it's interesting. You said a couple of things here that are subjective, right? Subjective to who the guardian may be, subjective to, the what your document actually says, subjective to interpretation. And you can walk into a court of law any day of the week and think you know what's going to happen, and something entirely different, and oftentimes entirely different happens than what you think is going to happen. It's really interesting. So I like that, because you're basically saying be very as specific as you can and as detailed as you can about what your final wishes are.
Yeah.
And Krista, in every situation I'm thinking about right now, had the parents been more intentful and more specific, I believe, the one family I'm thinking about right now, 4 kids, strong family unit. Now the 3 of the kids talk to each other, but one's estranged. One tried to move into mom's house and basically steal the house, when mom was dying. And I mean, just crazy stuff. And now they don't talk to each other anymore, except, it's odd, but 3 still talk. One doesn't talk at all. And, I knew the parents well, and they would be very upset to know that their family is in this state today. Really, really interesting stuff. All right. So let's talk about some new stuff, right? We were jumping on, and I was listening to some of your recent work, and there's been some law changes, recently. A lot of law changes going on right now, and a lot of new legislation, which is a big risk we talk about with our clients at Ally Wealth, because, we can believe that what's on the Hill right now is going to be the law forever. And it ain't, because you go through an election cycle in this country every 2 years. And if you live a 30-year retirement, that's 15 election cycles. That's a lot of stuff that could change legally for you, right? So we just had some legal changes in the probate area. What are those? And could you give us some insight on that?
Yeah. So when it comes to probate, it's important to understand the laws of your state. So the state changes that we had specifically in California is because the values of our houses here and the properties are high. They've actually raised the cap value of what is needed to go through probate. And so before, it was anything over 187,500 needed to go through probate. Right.
That's nearly every property in California.
Oh yeah, absolutely. And so what they said is, if you have a primary residence that is under $750,000, it no longer has to go through a full probate. We can file a petition that's going to make it faster to be able to get transferred to the beneficiaries at, it's going to be at less of a cost. It's not going to take as much. And so, there's changes going on like around that. But if you have rental properties, if you have retirement accounts, life insurance, anything where there's no beneficiary designation, that's still going to have to go through probate. So you could have a house that is going to avoid probate, but then all this other stuff that wasn't cared for, that's going to have to go through a full probate. So that's one of the big changes that we just had come down a few months ago.
Interesting. Very interesting. So Tell me this. I mean, let me ask you, kind of put you on the spot here with a couple of questions. Let's say I got $1 million in my 401k. I'm single. All right. I have no kids. And I own a house. All right. Do I need an estate plan?
So in California, if you are single and you do not have children, it really depends on who would you want to inherit. Right. And so if you have nieces and nephews that are maybe minor children, well, you wouldn't want to put minor children as beneficiaries on that retirement account, because they wouldn't actually be able to inherit that money until they turned 18 if something happened to you. And so it would be having a trust as the beneficiary for minor children. But maybe you have, I would want my parents or my siblings to be a beneficiary. Okay, well, then it wouldn't need to go through a trust, right? There's going to be better tax savings if it's going to be an individual rather than a trust generally. And so, you wouldn't need it for that. But the fact that you own a home, that is what puts you in the category of needing a trust. Because now if you own this home, again, over the value of $750,000, which honestly, like in the area that I'm in, median price for a home here is like $850,000, right? So we're still over that. And I know there's places in California that are 1.2 as the median price, right? 1.5. But there are some that are lower. So it really depends on that. But if you own a home and that it's over that value, it's going to have to go through some type of court proceeding, whether it's a shortened probate or a probate. So if you just had a trust, right? And if you were to get sick, right? What if you got in a car accident? You're very active, or flying a plane, something that rendered you incapacitated. Now you have family members that would have to step forward to get a conservatorship, right? That's going to cost a lot of money to get a conservatorship to be able to take care of you. Whereas if you had a trust, the trust plans for not only your passing, but during your life if you were to get sick. And so it allows somebody to step in to be able to maybe sell your house to be able to take care of you, right? Where they couldn't do that without having some type of court intervention.
And see,
so I would still say you need a trust.
It's just simple, right? Your money's in an IRA, 401k, which rolls up to an IRA when you retire, and you got a house. That's about you're single. That's about as simple as it gets, but that person still needs an estate plan. Right.
Yes.
And I'm trying to point that out because I think so many people overlook, as you said, the very basic stuff out there. And then one thing that is really interesting is this. Let's say that you did leave that 401k to those two nieces and nephews. Well, guess what? If they inherit that, that 401k has to be liquidated now over 10 years, regardless of who the beneficiary is. That creates a whole nother issue in itself, because who's going to handle that transaction? Who's going to deal with all that? Right. And it's going to likely be the guardian of the parents, of the parents of the children, of the guardians. Really, really interesting. What are some things that you can do, like, to ensure, and I guess where I'm trying to go is, like, how do I know the flow of money after I pass? Like, let's say that I do pass, and I've got children, and I want my money to pass through to my trust of my children, or my wife to live out of her irrevocable trust, and that go to my children, and my revocable trust that goes to my children already. I mean, the guidance of the trustee actually orchestrating the trust and the capacity it's supposed to be orchestrated in. What are some things that you can talk about around that? And what are some things that kind of hold people's feet to the fire to make sure that those things are being done the right way?
So unfortunately, there isn't like a trust police, right? And, we do estate planning in our firm, and then we also help families after somebody has passed away. And so whether it's through probate court, trust administration, or representing beneficiaries, where maybe the trustee isn't acting in accordance with what they're supposed to be doing, because it does happen. And so it's important when you're doing your estate plan to identify a trustee that you think is going to be truthful, and they're going to be fair, and they're going to do and follow the instructions that you want. Okay. They have a fiduciary capacity to be able to follow the instructions, to act the way that they should act in this capacity, because it is a financial capacity. If they are not, generally you would hope that there would be somebody in the estate that is a family member or a relative or somebody that can raise their hand and say, I don't think that this is right, and ask for clarification or ask for documentation on accounts or what's being done. Or you have to hire an attorney, right? And the attorney gets involved and they say, okay, we need this documentation. We need to know what you're doing, because we see this, right? Like you said, we have a trustee where they move their kid into the house, right? And now kid's living in the house rent free. My client, who's a beneficiary, is saying, I don't understand. This house is supposed to be sold and distributed between me and my sibling, and now her kid's living there rent free, right? So we had to get involved. We had to talk to the trustee, and they didn't want to talk to us. They wanted their kid to keep living there. They thought the house was theirs now. So we had to file an action in court, right? We were successful in this case in having the kid moved out. We also got back pay of rent for all of the time that they were living in that house. And then we forced the sale and were able to get the proceeds split between the two beneficiaries, right? But, depending on who the trustee is, they have that fiduciary duty to act responsibly, but they may not. Right. And somebody has to call them out, and it's either going to be verbal, it's going to be in writing, it's going to be arguing, and then probably lawyers getting involved.
Can you have multiple trustees to kind of, help facilitate that somebody is doing the right thing? Maybe have three, if you will. For instance, I know my trust, it's my dad, my brother, my wife, on the kids trust. So is there some, and then that can come with a whole root of complex issues. I know, believe me, but
okay. As long as you know that, I'm going to say that. So as long as you know, I'm bringing it.
Believe
So
me, but
I generally recommend not having co-trustees because if they don't agree, we have to go to court, right? If they can't come to some type of agreement. And so if you have two kids that have been fighting their whole life, when you pass away, don't assume everything is going to be rosy with them, right? Assume it's probably going to be worse because you're not there to make it better. And so don't put them together to act together and to work together in something that is probably not going to be successful. It all depends on who you're choosing, right? If it's two people that you think that they've gotten along, they work well together, then they probably will work together, right? But it just knowing that there is the possibility that if they don't agree on something, it's going to go to court.
It is interesting. There's a correlation between, the aging of mom and dad, the kids being informed that there's an estate plan. And as mom and dad get closer and closer and closer to going to meet their maker, the interest in what's going on financially from the heirs just increases over time. Some it's a very interesting dynamic. What are your thoughts about, really effectively communicating your wishes, your estate values, your trust information to your loved ones and your heirs? Should you do that? Is there an age you should do that? Is there an age you shouldn't do that? I mean, give me some insight on that and some from your expert opinion.
Generally, I will tell clients, you should be very clear and open and communicate with your family on what your wishes are. Who is going to be in charge? Who is the backup? Because where I find that the kids are left out of understanding or knowing what's going on, they only find out after the parent passes away. And it's almost like they feel a sense of betrayal and they come into it swinging, right? They're now in fighting mode for it because now they think, well, I was always the favorite. Why am I not being chosen? They must have been coerced into choosing this other person, right? If I'm not the one who's going to be in charge. And so it just starts fighting from the beginning. So have the communication early on. As soon as you do an estate plan, that makes it very clear so that it allows the children time to be able to come to terms with whatever your decision is. From an asset perspective, it's interesting because what I find with a lot of our older clients is they're very secretive on the money that they have. They do not want to share it with the kids. They don't want the kids to know. They don't even want to talk to them about money, right? And for some, it's like they don't even want to do estate planning because they don't want to think about it, right? And so a lot of times we'll get the adult kids that are bringing the parents in because they know they need a trust because they're the one that are going to have to go through probate if they don't do it. And so I don't think that it needs to be shared with the level of what the estate is worth with the assets that are there, but it needs to be documented so that when something happens, it is very clear. We have these accounts, we have these insurance policies, we have these properties, right? So that they're not having to dig through file cabinets and boxes and offices and garage to try and find all of these things because they have no idea, right? So if it's very clearly documented, again, it doesn't have to be shared, but just documented in one place, it's going to make life so much easier because now the kids are going to know and it's going to be organized for them.
Chris, I've learned a lot today. Even myself, I can't thank you enough for coming on the podcast. It's been a pleasure to have you on. This has been very, very enlightening and very, very informative in many, many ways. And the biggest thing for me to take away is the 18-year-old estate planning. I have never heard of that. I'm going to be calling quite a few clients who have kids in school and that sort of thing. I'm sure doing knuckleheaded things like we all did at one time, right? And having some conversations around that. But I can't thank you enough for coming on today. I really appreciate it.
Well, thank you for having me, Ryan. I appreciate it.
My pleasure. Well, folks, that'll do it for another great episode of Redefine Retirement with Ryan Wheless. I hope you got a tremendous amount of value out of today's episode. Stay in tune. We'll be back with more. Subscribe to Redefine Retirement on YouTube, Spotify, or wherever you listen to podcasts.